Welcome to the Buying Legal Counsel Legal Procurement Best Practices call on eDiscovery 5 considerations. Our expert is Chris Schultz. Welcome, Christopher. We're excited to learn from you today.
Sylvia, thank you very much, and thanks to the entire Buying Legal Counsel for the opportunity to speak to everyone today. Just two quick foundational points before we dig into the substance. First, as Sylvia just mentioned, I wish that we were all together in a room. It certainly facilitates dialogue. Those of you who have worked with me or know me in the past know that dialogue is very important to me. And so I would urge you, use the chat button, make a record of your comments or your questions as we go along. And we've set aside plenty of time at the end of this presentation to engage in that dialogue. The second general foundational point before we jump right in is that I know we have a lot of friends and a lot of colleagues that hail from overseas, and especially from Europe. And you may be on this webinar right now. This talk, this presentation will be focused on the uniquely American or United States, and specifically the federal practice of discovery in the United States. As Sylvia and I have discussed, perhaps in 2019, it would be interesting and frankly valuable to do a bit of a compare and contrast or a comparative legal presentation on the very different ways that discovery is practiced and priced in Europe and in Asia Pacific, for example. But for today, we're going to be focusing on the federal practice of discovery as it is in the United States, and really as it has existed since the early 1920s here in the United States. So please keep track of your comments, and with that foundational item about what we'll be looking at, let's dive right in. Typically, when I give this presentation in a room of people, I'll ask for a show of hands. How many people have seen before the graphic that you see on your screen right now? It's the electronic discovery reference model. It dates to approximately 2003 or so, when George Sosha up in Minnesota brought together the eDRM. Now, as you can see from this graphic, the eDRM has now merged with Duke College of Law. It's now housed as a think tank and a best practices think tank for eDiscovery and discovery generally at Duke Law. But you can see that especially back in 2003, which was prior to the major eDiscovery amendments to the Federal Rules of Civil Procedure, those are the rules that control all aspects of litigation in the federal courts, including discovery. It was a bit helpful to all of us practicing, because as you can see, it identifies the major life cycle steps in a discovery project, starting with identification on the left-hand side through production, either to your opponents or to the court, on the right-hand side. Over the years, this model has been expanded both on the left with information governance, we'll speak about that at the end of the presentation today, and on the right, talking more about presentation of evidence, either at trial or perhaps during deposition, this type of thing. But I would commend to you the eDRM. Certainly take a look at their website. You'll find lots of checklists and good resources there in each of the areas that we'll speak about today. The 5 considerations that we'll speak about today are really the identification, preservation, collection, and then processing, review, analysis, and production stages in the eDRM. And so with that as our foundation, let's take a look at some best practices when it comes to identifying evidence that may be used either in a piece of litigation or a subpoena response or some sort of investigatory action. The first point, and this is something that I remind especially younger lawyers all the time, when you think about identifying relevant or potentially relevant evidence or documents in a dispute, I think the mind should always go back to the elements of the claims that are being brought against the defendant and the elements of the defenses that that defendant or defendants may want to raise against those claims. And it seems basic, it seems foundational, but you'd be surprised how many people jump into the fray of discovery without taking a deep breath, without pausing, and without going back to the basics, which are the elements of the claims that are being brought against you, and the elements of the defenses that you might want to raise. As you can see here, the first sub-point, those elements really do determine what is potentially relevant and what you should identify for preservation, which we'll come to in the next consideration. Now, think about how you would go about knowing what those elements of claims and defenses might be. You might have received a demand letter. You very well may have received a Rule 45 subpoena from a third party. You may have received either a draft complaint or an actual complaint. You may be an actual defendant at this point, right? You may have received with that complaint, or as the timing of the federal rules allow, discovery requests, either requests for production of documents or requests for admissions, or requests for inspection of things and other items. There could be other triggering documents as well, certain communications from the federal government, for example, that may give you some insight as to what those claims and defenses are going to be. And what I like to suggest to the attorneys that work with us is that really match those claims and defenses and start brainstorming what type of evidence would we need to identify to either prove up those claims or defend against them. And that's really the best way to go about starting to think about the identification of potentially relevant, potentially responsive material. Notice the final sub-bullet under the first point. There is in the United States both statutory and common law duties of non-spoliation of evidence, and that's just a fancy word for you can't destroy potentially relevant evidence to the detriment of your opponent. That resonates with us. It's a foundational principle of fairness, and some pretty bad consequences can happen to parties that spoliate evidence, either intentionally or to a lesser degree negligently. And so again, one of the best ways to avoid going down the rabbit hole of spoliation, which is never something that a client wants to see, is to start matching up those elements of claims and defenses with the potential sources of evidence that may support them. Now, the next major bullet here, think about the human content creators. Every corporation, I don't care how large or whether it's a startup, it functions through people. Those people are constantly creating content, whether they are creating a new Slack channel to share information with their colleagues in real time, or perhaps using an enterprise instant messaging platform to quickly communicate with professionals around the world. Of course, don't forget about the old, I say at this point, the old standard of email. Email seems to be more of an older method of communication now, but it's still a hugely important source of potential evidence and potentially responsive evidence in most cases. Human content creators, and as you think about the elements of the claims and defenses, you'll figure out who those people probably are, will be creating all of that type of electronic evidence that you'll want to identify and then ultimately preserve. Now, the second subpoint is we just don't think about humans anymore. We think about so-called electronic content creators. Imagine in the UK, the ubiquity of the cameras and the surveillance cameras that are on every street corner. Think about the time keeping systems in the United States as employees clock in and clock out. All of these electronic systems are 24/7 spinning off potentially relevant information that could make or break a piece of litigation or an investigation. So we can't just think about human content creators. We have to think about electronic so-called content creators as well. The third point, and this will come as no surprise, one of the first things that I like to do when getting involved in an engagement is to get the most recent organizational charts that I can get my hands on. I like to scribble on them. It's a little bit of a joke, but you can actually start to put these on a wall, kind of like you'd see on a CSI, right, type program on the television, and start drawing connections between people and data. And that's how we go about identifying what may be potentially relevant. This phrase of art, IT data maps, in my experience, they are important. But in my experience, they are often out of date. It's the rare corporate client that really has a very robust, very up-to-date map of all of the systems where potentially relevant information may be stored. Those IT data maps, very often we have to bring those up to date right at the beginning of matters, and you can see why that's important. And then, of course, the final point is that in-person interviews are really, really hard to beat. It's the same reason why these webinars are very good. It allows us to reach our colleagues and our friends across the world, but there are challenges when you're virtual, when you're not face-to-face. I always find that people tend to locate potentially relevant information faster, and there are aha moments often in person as opposed to virtual. So to the extent that you're able to go and sit face-to-face with the human content creators, get your hands on the electronic content creators, I think that's always a very helpful thing to do. Now, we've talked a little about this already. Where might this material reside? It used to be a lot easier. It used to be physical locations back in the day when those of us that have been practicing for a while would simply go and collect banker's boxes full of paper records. Those days, paper records still exist, but I would say that they are eclipsed tremendously by the software and the hardware that we've been talking about that are spinning off constantly these tranches of electronic data. Also, don't forget the final point there. Don't forget about so-called outside systems, SaaS systems, software as a service, hardware as a service, the cloud. Think about Amazon Web Services. Think about Microsoft Azure, right? There is a lot of your clients and your corporation's data that now exists, perhaps not completely outside of your care, custody, and control, but certainly outside of your physical infrastructure. And that information needs to be identified and preserved as well, lest the specter of spoliation raise its head there as well. Now, I think I have on a later slide, go back one second, Sylvia, if you don't mind, the checklists. I have on a future slide one of my favorite books, The Checklist Manifesto. In fact, I'm looking at it here in my office right now. The basic premise, if you've read that book, of a good checklist is that it really doesn't matter how smart you are. It doesn't matter how long you've been doing your job. It doesn't really matter whether you're flying an airplane, operating on a patient in a surgical suite, or conducting eDiscovery. Every professional really should have a checklist to make sure that things are not falling through the cracks. And you can imagine in this identification process that we've just spoken about how important that is. The Sedona conference will provide some links to their website, and of course, EDRM have some excellent checklists that I would recommend to you, and that if you're practicing in these areas, you know, a professional ought to have at the ready. So nothing shameful about using a checklist. I use them every day, and I think all good professionals should. Okay, let's move forward. Preservation. You've identified potentially relevant material. Now, of course, to avoid spoliation, you must preserve it. Let's take a look at the first bullet. From the earliest, one of the earliest judges to speak about eDiscovery was the Honorable Shira Schindlin in the Southern District of New York, and she wrote a series of seminal cases that were called the Zubalake cases. And from those earliest cases, what Judge Schindlin had said, and what is now actually black letter law, is that you're probably committing professional malpractice if you're not issuing written document hold notices to the content creators, the IT professionals that we've talked about, the people that are in charge of these electronic systems that are spinning off potentially relevant information, and to third parties, including those third parties that may host your software as a service or your hardware as a service. So written document hold notices to preserve information once you've identified who needs to receive them are absolutely critical. You can see that plain English and not lawyer speak is not only the goal, but really, as the law has developed, it's really what's required. Because of course, a written document hold notice loses its value if it can't be understood by a non-attorney. The goal, of course, of these notices is the preservation, the safekeeping of information and documents. Something that's in lawyer speak that no one can understand, it just isn't as effective toward that goal. Typically, we will include a general background of the matter. So for example, if your corporation has been sued, we will provide the employees that have been identified as potential content creators or IT professionals with a general background of the matter. I think humans generally tend to do better when they understand the background. And so the lawyers need to be involved in the crafting of that paragraph or two. You don't want to say too much, you don't want to say too little, but I think that it's always good to give people a sense of the forest rather than the trees and why this matters. Obviously, the second point there, you need to identify the ESI, that's the electronically stored information, and any other materials that need to be preserved. And thirdly, not surprisingly, there need to be instructions given. These are often non-attorneys. These are often lay people who have a day job to do. One of the last things they probably want to do is read a multi-page document hold notice from the legal department and still have to do their day job, right? So you need to give the items to be preserved, but also some clear instructions for how that needs to happen. I have the word here, consider a frequently asked question document. I think probably the word consider should be struck. I think an FAQ document is very helpful to the people who receive these notices. And frankly, it will help you manage your workload, because if you don't have that FAQ document, you're going to have to field most likely those questions that will come in by email or telephone. Again, you'll notice my penchant for in-person meetings. You know, if the group of people is relatively modest, and they tend to be in one location, for example, I think an in-person meeting, obviously counsel needs to be there so that we can cloak it in privilege and work product protection. But an in-person meeting to really drive home the importance of the notice and to talk about those instructions for preservation, really just can't be beat. So at least an FAQ document and in-person meetings, if at all possible. And then, of course, we have to sound like lawyers. Every person who gets one of these documents needs to execute or sign an acknowledgement that they have received, understood, and will comply with the instructions that are included in that document. And that's just a great documentation practice that needs to be adhered to. Okay, moving on. Of course, it's not enough just to issue those hold notices. They have to be managed. The list of people and IT professionals and third parties and electronic systems needs to remain accurate, and it needs to remain complete, and it needs to be both now and going forward. So as you can see, this is it's an ongoing preservation duty. Parties can be held to do everything correctly in the beginning and yet still spoliate if they're not keeping their notices up to date and accurate. Periodic reminders and acknowledgments, again, that the party or the person has received, understood, and will comply are critical. I will say, there's not a bullet to this point, I should probably add one, that there are software packages available to help you manage this process. Back in the day, many of us would manage it using Microsoft Excel, for example. Those days are largely gone. There's good software, including software as a service, that you can use to really make sure that your hold notices are going to the right people and being updated and managed appropriately. And then, of course, the final point before we move on, coordination with the Human Resources Department and the IT department are crucial. Why is that? Well, people's equipment tends to fail. Laptop hard drives fail. People get new equipment on some sort of a rotational basis at the company. If the IT department doesn't know that a given person is on a document hold notice, what might they do? They very well may wipe or redeploy that machine. And if the information on that machine hasn't been collected or harvested yet, you've just spoliated evidence. So you just don't want to be in that position. So the IT department needs to know who's on a hold notice. Same with your Human Resources Department. Obviously, employees change departments. They change divisions within a company. They also come and they go. They depart the company. And again, if they are on a hold notice, they have potentially relevant material stored in their Slack channel, in their network share drive, on their laptop. We'd want to preserve that before allowing those resources to either be wiped or redeployed if they depart the company. So again, just a general admonition to coordinate with the HR and IT departments. We'll let the next bullet come in. I like to say to clients all the time, preserve broadly and produce as appropriate. I think that's a very nice way to avoid spoliation. And when you think about preserving broadly, you need to think about suspending parts of, or perhaps all of, your normal document retention policies. You need to think about suspending any automatic email purging that the company may have in place. I think even at my company, we have a protocol in place, unless a person is on a hold notice, whereby information in the inbox is automatically purged after 90 days. It's a very common way that IT departments manage their capacity, right? And so those automatic email purging protocols may need to be suspended. There are other data management protocols that may need to be suspended. Think about, for example, those security cameras that we spoke of earlier. Very often, because those tend to spin off a lot of data very quickly, those tapes or magnetic media don't hold or go back in time very far. So you may want to preserve those if they are important, knowing, of course, that they will be overwritten in the ordinary course relatively quickly if those protocols are not overrode. Backup systems are not primary, but consider initial preservation. Depending on the jurisdiction that you're in the United States, you may not need to preserve or produce information from disaster recovery backup systems in the first instance, but there are some very clear exceptions to that rule that we can talk about perhaps during the dialogue or offline. So again, typically, we're not worried about backup systems, but certainly consider initial preservation of them if you think some of those exceptions may apply. All right. Yes, and no surprise, document everything. There's the reference to the Checklist Manifesto, one of my favorite books. I like to say to colleagues and to clients, it's typically 1.5 years down the road before we get some sort of spoliation motion. I jokingly say to my family, I can barely remember what I had for breakfast, let alone all of the steps that we took 1.5 years ago to preserve and identify and collect information. So document everything. And again, there's the reference to the Sedona Conference and EDRM that have some excellent checklists that you can use. All right, let's move forward. Collection. Obviously, if you've identified material, if you've preserved it, you have to collect it. And how times have changed. Back in the back when I first started practicing law, we would dispatch paralegals or other allied professionals, or sometimes even have content creators self-collect their information. And those days are just really over. Custodians don't know how to do it correctly. They will mess up all of the metadata that's associated with the documents. And the last thing that we really want are our paralegals at the law firm or other allied professionals to be put on the stand, either in deposition or otherwise at a hearing, to testify how they may have botched or even how they just went about doing a collection. And so, as we go to the next point, you have options. And forensic collection options are the most comprehensive. These options take a bit-by-bit image of a hard drive or an other electronic data source. Forensic collection tends to be important if the allegations, we're going to go back to it again, the allegations or the claims and the elements of your case might make deleted documents important, or slack space on a hard drive where there's no present data currently residing important. They'll capture all of that, and we can forensically evaluate what might be in those spaces back in the laboratory. And notice, of course, all metadata is preserved precisely. Again, that can be important because when a document was actually crafted or drafted could very well be dispositive in a case. One level below a full forensic collection would be a targeted forensic collection. Notice that this involves active files and directories that the legal team in consultation with the client thinks might actually matter. Notice, however, that it does not include that slack space. So again, going back to the claims and defenses and what are we trying to prove or defend against can help you make the choice between those two options. And finally, there are, as we let the final bullet come in, there's non-forensic collection options. I do have certain corporate clients with sophisticated IT departments that have dedicated professionals who are able to use operating system commands to copy electronic data that we care about. That is marginally riskier than having a third-party forensic consultant come in and do those collections. But for a host of reasons, cost containment, the relative risk of a piece of litigation, it may very well be an acceptable collection option. And so we list it here as an option for completeness. Sylvia, let's move forward. Processing, review, and analysis. This is, and I'm looking at the time, we're at about 10:40. I want to get to dialogue here fairly quickly. This is the most costly and complicated stage of the life cycle, short of trial itself. In other words, most of the money is spent in the processing, review, and analysis of the evidence than all of the other stages we've just talked about. I wrote a blog post that's available at our website regarding the three-legged stool. Wrote it with one of my colleagues here at the firm. And when we think about processing, review, and analysis, we always think about three things: the data, and it really is the data, the data, the data, right? It's all about the data. Getting the right team in place and making sure that the deadlines are both reasonable and achievable. Why do we speak of the data? Because data minimization, preserving broadly, but producing and reviewing as appropriate is really the best way to contain the cost of this most expensive component of the eDiscovery lifecycle. We'll speak more about ways to limit data here in just a moment. The team is also very important. Preferably, you would want team members reviewing the evidence that know the corporate client, that know the acronyms that are used, that have some sense of the org chart, that know the type of documents that the client typically spins off. The team is important, not only for quality, but also for cost containment. And obviously the deadlines. The faster things have to happen, typically the less efficient things are, and the more expensive things become. So, you know, I like to say to people all the time, we would prefer to be the 411 call, the information call, as opposed to the 911 call, the emergency call. We'll take the emergency call, and we do it often, but it's always better to have enough time to negotiate reasonable deadlines, which always drives, I think, better quality and better cost containment. Let's talk about, very briefly, some best practices when it comes to managed review. You know, the days are really gone where you can forego having a project manager. Think about the importance of having a single point of contact, interfacing with outside counsel, interfacing with the client, making sure that all of the steps and stages we've just talked about are executed appropriately and with good documentation. Think about a person who can help with bringing together the review protocol, helping with the kickoff of a managed review project, helping with, as you can see here, the daily progress updates that go to outside counsel and that go to the end corporate client. Don't forget about quality control. We literally could have an entire hour-long presentation on best practices surrounding quality control in the review process. Technology, I've placed an asterisk there because we're going to actually dive into it next. I figured that was one space that we really should talk about on this call. The technology can help, and thank goodness, because we haven't had it always. And then, of course, decision logging, or as I put it before, documenting everything. You've got to have a person who is writing herd, as we say, on making sure that everything is documented accurately and completely, lest things fall through the cracks and lest we try to recreate and remember, you know, what happened 1.5 years ago. Let's talk briefly, as we go to the next slide, then about technology. There's some basic ways that we can now, remember I said it's all about the data. Here's some basic ways that we can go about limiting data, and the software as a service that we use to review documents can help us with each of these. There are certain file types when we harvest documents from a hard drive that we simply don't care about in most cases. There are a host of operating system files and other types that we just don't care about. And the software can help us preserve those materials so that we don't have any potential allegation of spoliation, but we can also set them aside because they're simply likely, if not highly likely, to be irrelevant. Think about relevant or key dates. It is, well, I can't think of a piece of litigation or an investigation that I've ever had the privilege of being a part of where we couldn't narrow to relevant and key points in time. The software allows us to filter documents provided the metadata associated with those documents is accurate and complete, which goes back to the importance of the collection phase. The metadata helps us limit the evidence to relevant or key dates. And again, that helps winnow and narrow the set of data that we care about. Custodians, goes without saying. We might preserve broadly a number of employees at a company, but frankly, in the first instance, we may not need to look at all of those custodians' evidence. Some custodians will be more important than others, and we can triage and start with them. Think about email domains. The software allows us to very rapidly remove from tranches of email domains that we don't care about. So if you get a bunch of stuff from the New York Times or Amazon.com or whatever, those domains are likely irrelevant to the lawsuit or the investigation at hand. We simply strip those out and we don't have to spend time or money looking at them. Think about as well, the software can help us do to and from selections. Going back to the custodians, there's probably people who are communicating with each other that we care about more than others. And thank goodness in 2018, the software, and for some time, has allowed us to filter so that we can only look at those emails that we really care about. Those are some basic data limits. As we go forward, intermediate data limits. Good old-fashioned Boolean searching. And for all of us who are attorneys on this call, all of us are familiar with Boolean searching. We learned it in law school when we learned how to use Westlaw and LexisNexis, right? Good old-fashioned Boolean searching. But that searching must be optimized. It is critical that you test and prioritize your search terms, that you're sampling in a statistically relevant and defensible manner to identify over and under inclusive hits. You need to always be suggesting limiting logic to the search terms as appropriate. And notice, of course, it's important to iterate and once again, document everything. So Boolean searching, good old-fashioned Boolean searching is a great intermediate way to limit data as well. Let's go to the final technology bullet, which is the advanced ways. And this is where probably everyone on this call has heard of TAR, technology-assisted review, or machine learning, or analytics. And again, I say, thank goodness we live in 2018, because the advanced analytics that the software that we use to review documents can now help us identify duplicate documents and near duplicate documents. In an attorney's mind, certainly in my mind, consistency is everything. And so we need to both identify the duplicate documents and suppress the true duplicates and really just deal with a single instance of a piece of evidence. And the software can now help us winnow and narrow the set in that way. Email threading, there's the parenthetical, consistency is king. You can imagine when we collect documents from a number of custodians at a corporation, all of those custodians that matter might have the same email threads multiplied by 10, 20, 30 people. We don't need to see all of those. We need to see a single unified email thread. And again, the software can help us with that. Document clustering and categorization. Some software platforms can bring together buckets of documents that are clustered around certain categories or topics that the attorneys and the professionals working on the case may care about. We can triage those. We can look at those first. We can set aside certain buckets that we know are not going to be important. The software can help with that. Keyword expansion and concept searching helps us make our Boolean searching even stronger and better. Don't forget about machine translation of foreign language documents. A really helpful way, at least in the first instance, to determine, is a language in a foreign language, a document in a foreign language, potentially relevant, or can we simply skip it because they're talking about, going to the cafe to have lunch? Machine translation in the first instance, followed by a foreign language expert's analysis, if the document looks interesting, is a very powerful tool. Intelligent batching and review prioritization used to be a manual process for our project managers, and now again, thank goodness, the software helps us with that. Let's go to the next slide. And this is really where we talk about predictive coding, or TAR. TAR 1.0 used to be that a subject matter expert would seed the computer algorithm with documents that we care about, and the algorithm would then, using that seed set, go through a tranche of documents and attempt to find similar documents. Now with TAR 2.0, the algorithms are becoming much more intelligent, for lack of a better word. They are continuously adjusting what might be relevant or potentially responsive based on the real-time coding activity of the attorneys that are marking documents responsive or not responsive, privileged or not privileged. And so again, these tools can be very helpful in winnowing very quickly a large data set. Notice this point. They can be used in conjunction with all of the basic and intermediate processes that we spoke of earlier. So you can use a lot of those date limitations, custodial limitations, file type limitations in the first instance, and then still run a predictive coding algorithm against the resulting set. And what are you doing? You're defensively winnowing the set even further. Sylvia, we're running close. It's about 10:50. Let's get to production quickly, and then I want to open the line to questions. Producing documents, it's all about meet and confer. And those of us who practice in federal courts know that it's the Federal Rule 26F conferences where these meet and confers with opponents happen. I think it's very critical to bring along a draft ESI stipulation and proposed order with you, and also your privilege protection 502D agreements. It's always great to have that at the ready. You speak about what's going to go into that stipulation and proposed order. It covers many of the things that we've talked about here, including potentially the custodians that would be collected from, the methodology that would be used for it, how documents will be produced, the deadlines on which items will be produced. It's a critical process that, again, we could have an entire 60-minute best practice on, but just know that those Federal Rule of 26F meetings are important. They're so important that you've got to do your homework. You've got to have the identification, preservation, and collection phases that we just spoke of really under your belt, and you've got to know what's happened in each of those going into that 26F meeting. And of course, this is good advice probably for life generally, and certainly in the law. Don't overpromise and underdeliver in a 26F. If you don't know, or if you need to go back and consult with your consultants, your technology consultants, your IT consultants, do it. The last thing you want to do is to overpromise and then not be able to deliver on certain obligations that you may obligate yourself to during that 26F. And then there's just a very quick note about a reasonably usable format. The federal rules require that documents or evidence be produced either in the form in which they are ordinarily kept in the ordinary course of business, or in a reasonably usable format by your opponent. And you can see there some of the elements of what that usable format may be. And that would also be part of your ESI stipulation and proposed order that you would negotiate with your opponent as part of that 26F. All right, let's go quickly. There it is again. We've just stepped through the major stages. Let's go to the next slide. A word about cost containment. Information governance, which is at the left-hand side of the EDRM, making sure that you've got a plan for a document retention policy and related schedule is a great way to limit the data. Again, everything comes back to defensible data reduction. Litigation readiness planning, having processes and checklists in place so you don't have to recreate the wheel when the inevitable litigation hits or the investigation comes, is a great way to have cost containment. Cooperation. The Sedona Conference has wonderful resources on ways to properly negotiate during a Rule 26 conference. Not everything needs to be a battle. Some of this stuff is simply within the purview of information technology. It shouldn't be a battle. Some cooperation and some reasonable dialogue during those 26 Fs can go a long way toward containing costs. Don't forget about motion practice if you need it. Proportionality principles, which are now embedded with the most recent rule edits and rule changes to the federal rules, can be very important. And then, of course, again, there's that three-legged stool that we mentioned earlier, and thinking about always ways to reduce, defensively reduce the data. All right, I've listed here, I know that the slides will be made available to people, some resources that you may want to consider. There's the Sedona Conference, there's the EDRM. Let me say just a quick word about that little pamphlet in the middle. It's from the Federal Judicial Center. It's used to train judges in the United States, in the federal courts, about managing electronic discovery. I think it's an excellent little primer that you should have on your desk. So I'd urge you to grab a copy of it from the FJC website. And then, of course, I had to put in a shameless plug to my blog and our blog here at Level 2 Legal there at the bottom. This is a picture of Sisyphus. Those of you that know your Greek mythology know that he was destined to roll that boulder up the hill every day, and then it would roll back down again. We feel like that sometimes with the data deluge in eDiscovery, but hopefully using some of these best practices we've just talked about, you can break that cycle and won't feel quite as demoralized as that data starts to roll down the hill each and every time. So with that, Sylvia, I'll turn it back to you and open the mics.